It is Two Wants to Know, where we take your questions to a team of experts. Today, we are covering everything legal. Want to know more about employment safety, what your workplace can and cannot ask you to do? What about divorce and family matters during COVID? Nicole Patino from the offices of Fred T. Hamlet and Hillary Hux from Garrett, Walker, Akoff, and Olson are here to answer your legal-related questions. You can text those questions to 336-379-5775. Again, this is text only, so do not call. We're going to start with a workplace issue question. So, Nicole, that is you. This person here says, if you're out with COVID, can your workplace force you to take your vacation day, and then can you draw unemployment when you're out of work with the virus?
Those are separate questions. So yes, they may be able to force you to take your vacation days. As we've discussed before, there's no more paid leave for COVID from the federal government, at least not right now. And unless your employer opts to go through the first quarter. So check with HR. You can also apply for unemployment benefits. It depends on how long you're going to be out of work. And there's also a requirement that you have to be fit for work and available to work. So if you can't go to work, you may not be eligible.
Right. If you are quarantining or that kind of thing, or if you actually have COVID, you are not fit to work.
Right.
Although it's interesting because there's a lot of people who work from home and that is an option. Does that come into play?
Yeah, if you work from home, then you would not be eligible for unemployment benefits, and you shouldn't have to take any vacation pay. You should just be able to work from home. Yeah.
Okay, this sounds like a family law question, and I've never actually had this question, Hillary. I don't know that you have either, and it's okay if we're kind of like, I don't know. This person says, how can I go about dealing with getting my stimulus check if it was sent to my ex-wife?
So if it was sent to your ex and deposited in that person's account and you can't resolve it just by talking with them, I mean, you might have some sort of like unjust enrichment type claim against them, but honestly, you'd probably end up spending about what that stimulus check is trying to fight that in court. I would think your best option would just be to kind of try to work that out in some kind of friendly manner. That's probably a little bit far on the fringes of family law and slightly outside my area, but I think that's probably my best advice.
Okay, and that is something what, depending on whether your name was on it, both of y'all's name was on it, that kind of stuff, that can make a difference in that too. We do want to cover some very common questions that family law gets. And so this is one of the most common questions, and it's a parental disagreement. So it kind of follows up on this text. It says, I disagree with my child's other parent about how to handle, and then you can fill in the blank with all kinds of things, from taking them to remote school, putting them in in-person school, taking certain risks, travel, mass, eating out, whatever it happens to be. So if you have a disagreement with your child's other parent about how to handle something, what do you do?
So the first thing you'd want to do is look at your custody order if you have one, because that's going to tell you who has legal custody over that child. If you have joint legal custody, then most of those decisions are decisions that are going to be mutually agreed upon by both parents. Legal custody refers to the big decisions like healthcare, education, religious upbringing, things like that. If you don't have a custody order, it probably is going to kind of default to joint legal custody and needing to make those decisions together. But if it's really becoming a problem and you don't have a custody order, now might be a good time to seek one.
Okay. And of course, you need to go through your lawyer to get that custody order. All right, Nicole, this person is asking, can your employer make you work through lunch with pay if you work a 40-hour week?
Absolutely. There's no requirement in North Carolina to give you a lunch break or breaks at all. So as long as the employer is paying you, you get lunch. So that's good.
So I guess, and I don't know if the person who was texting meant like because they're salaried or because they're by the hour.
So if there is a lunch break and the employer decides that they're not going to pay you, you have to be relieved from duty. You can't take calls. You have to totally stop working, and it has to be for at least 20 minutes. And that's if you're not getting paid. But if you are getting paid, I mean, yeah, they can make you work. They
Through
can
lunch.
make you work to get paid.
Okay. And that's an interesting sticking point that I did not know, that in North Carolina, they don't have to give you a 15-minute break in the morning, 15-minute break in the afternoon, half-hour break for lunch?
No, no break requirement at all.
Okay, good to know. All right, so this person is asking, how do you know if you have a case for being fired unlawfully?
North Carolina is an at-will employment state, so in general, you can be fired for any reason except what we call bad reasons. A bad reason would be unlawful discrimination. So that's going to be discrimination based on race, gender, religion, ethnic origin, disability, veteran status, something like that, or violation of public policy. So if your employer asks you to commit fraud on the job, to drive longer than DOT allows, things like that. If they're asking you to break the law, that would be, and you don't, and they fire you, that's an unlawful reason.
So if you do feel, though, that you were fired unlawfully, do you start with the Labor Commission?
Well, it depends. It depends on why you think you were wrongly terminated. I would call an attorney. Most labor and employment attorneys will listen to what you have to say, what led up to that termination. And if we can't help, or if there's a government agency that can, we'll send you that way.
And when she says we will listen to you and send you that way, they mean without charging you. Whether you're talking to someone on the phone and you have not entered into an agreement with them, they can guide you to your next steps.
Right.
Okay. All right. We're going to take a quick break and we're going to continue to take your text questions. I want to make sure that you see that number down at the bottom of your screen, 336-379-5775. And we will be back talking about family law and workplace issues.